Thank you all for coming. Welcome again. My name is Linda Aragon, and I'm the Adult Programming Librarian for the Fresno County Public Library. Tonight's program is sponsored by a grant from California Reads, which is part of the California Humanities Council Searching for Democracy initiative. The purpose of the grant is to engage communities during this national election year and discussions about democracy through the reading of democracy-themed books. The library chose the book Farewell to Manzanar by Jean Wakatsuki Houston and James Houston because of its relevance to our community, in that Fresno was the location of not one, but 2 assembly centers for the relocation of Japanese American citizens. Fresno has had a long history of contributions from its Japanese American citizens, mostly because of its agricultural roots and the resulting businesses that accompany it. The Kogetsu Dough Bakery in Chinatown, where tonight you enjoyed that delicious mochi, has been in business for 97 years. Think about it for a moment, 97 years. Many of our parents, grandparents, and even our great-grandparents hadn't even come to this country yet. The current owner's grandparents were sent to an internment camp, and a Chinese family rented their home and their bakery and kept it going for them during their internment years. They were among the lucky ones. Many people lost their homes, their businesses, their livelihoods. There is hardly a family of Japanese ancestry in the valley that has not been touched by Executive Order 9066. Tonight's program is part of a series of month-long events and activities that we hope will pique people's interest in reading the book and learning about an episode in American history and about the meaning of democracy, its past, its present, and its future. Now, I would like to introduce some of our major sponsors for tonight's event, and I'd like to invite them up to say a few words. I would like to invite up the Fresno Art Museum Director, Linda Gano, who has been instrumental in hosting this event, as well as putting together the Ansel Adams Manzanar exhibit.
And welcome to the Fresno Art Museum. Thank you all for coming. I would like to thank our sponsors, Comcast, also our partners, the Fresno County Public Library, Cal Humanities, the California Center for the Book, and Cal State Library. It's been a pleasure to work with Linda Aragon and Roberta Barton and also Martha Connor on this project. They've been incredible, and I want to thank you for giving us the opportunity to host this very, very enlightening and exciting event, exhibition, and be part of this program. On a personal note, thank you so much, because this has allowed me to further my vision for the Fresno Art Museum, and that is to make this a place that connects with our community and also that has a strong educational mission. So this has been a great opportunity for us to do just that. And personally, it's given me the opportunity to understand and to research a topic that I am humiliated, embarrassed to say that I knew very, very little about. And it certainly has been enlightening to find out about Ansel Adams' own ambivalent feelings about this, as he says, truly regrettable stain on the record of our democracy. And thank you to our distinguished panel for joining us. It's such an honor to have all of you here. And Linda, thank you once again for allowing us to participate in this amazing program for our community. And thank all of you for coming tonight.
Next, I'd like to invite up Jack Hall, Director of Government Affairs at Comcast, for his contribution to tonight's reception, as well as honorariums for our panelists.
Thank you, Linda. Thank you, everyone. When Roberta called me and asked would we be interested in sponsoring an event like this, I didn't hesitate. It's something that, as a company that has a strong role in the community, that we right away jumped at. But Comcast is very proud to be associated with an event like this, to be here tonight with our panelists and all of you. Literacy is the foundation of our community giving for Comcast. So partnering with the library was just an automatic for us. But being here tonight and seeing a tragedy through such beautiful photographs, being here tonight and hearing this panel being able to present on something that we must never forget, it is something that touches all of us. And it reminded me that tonight we must truly affirm that we are all participating in a democracy. I looked up a quote that said, and it was anonymous, forgive me, democracy is not what we have, democracy is what we do. Let's all enjoy this evening, and thank you again for all being here.
Next, we have Marcia Chung from the JACL, Japanese American Citizens League, and the CCDC Governor.
Thank you. On behalf of the CCDC JACL organization, we want to welcome and thank the Quorum Novus team for returning to Fresno again. We sponsored a tri-district conference in 2009, and they graciously came and were the panel speaker for us, and we had nothing but rave reviews on their discussion, and we're really proud to have them back. Thank you very much for coming back and representing Fred Carmazzo. We really do appreciate you, and all the liberties that we have at this day, we owe much of it to you. So thank you very much.
I would also like to thank the Central California Asian Pacific American Bar Association, the ACLU, the National Raisin Company, and University Square Hotel as sponsors also. I would also like to take a moment to acknowledge someone who has put her heart and soul and worked tirelessly to help put these events together. My co-partner in crime with Roberta. And now for our main event, get to the heart of the matter. I would like to introduce our panel moderator this evening, the Honorable Judge Dale Akita. He has been a judge of the Fresno County Superior Court since 2001. He was District Governor and National Legal Counsel for the Japanese American Citizens League and chaired the Office of Redress Administration Ceremony for the presentation of the first redress payments in Central California. Judge Akita chaired committees for the to Japanese Americans interned at the Pinedale and Fresno Assembly Centers during World War II, and co-chaired this year's California Congressional Gold Medal Ceremony to honor Japanese American VC veterans of World War II. Please let us welcome Judge Dale Akita.
Thank you, Linda, for that generous introduction. Most of that is in the handout for the program, and I asked Linda, please, we don't have a lot of time, keep it short. That was very nice, Linda, thank you very much. On behalf of our panel, I'd like to thank all of you for being present, taking time out of your busy day to be here. I understand we have an overflow audience. We're very gratified to see so many people in attendance. And I also want to add our thanks to the Fresno County Library that is sponsoring this Farewell to Manzanar series, as well as the Fresno Art Museum for providing this beautiful facility. Let's give them another hand. And thank you for the many sponsors that have made this possible. I'd like to introduce our panel, and like I said, we don't have a lot of time, so I refer you to your program handout that has a more detailed description, but as noted, we have 3 of the attorneys from the Fred Korematsu Quorum Nobis case here with us tonight, including Karen Kai, we put her kind of in the middle, a female, or decoration, if you will, or the best looking I take it back. I meant to say most attractive members. She, among her many tasks, served as liaison with 2 other litigants, Gordon Hirabayashi and Minya Sui. And to her right is Bob Rusky. Her husband, I found out that they were married before this case, which goes back to the 80s, so they've been together a long time. Bob was also on the Fred Korematsu Quorum Nobis case. And we also have Don Tamaki, closest to me. He is one of the named partners of Minami Tamaki Law Firm, which is one of the top law firms in San Francisco. At the time of the Quorum Nobis case, he was the executive director of the Asian Law Caucus, which was the nation's first public interest law firm representing Asian Americans in civil rights and poverty law cases. And he was in charge of the public outreach and education program. My job is to give a little bit of historic background on the Quorum Nobis case and how it fits into the overall story of the internment of Japanese Americans during World War II. December 7, 1941 was a traumatic day for the nation, but especially for Japanese Americans who feared what the repercussions would be on them. And as a result of that, an Executive Order 9066 was issued by President Roosevelt authorizing the Secretary of War and his designee to establish military zones from which any and all persons could be excluded. That was used by General John L. DeWitt to issue a number of orders, including travel restrictions, curfews, and exclusion and ultimately detention orders that applied to just Japanese Americans on the West Coast. As a result, over 110,000 Americans of Japanese ancestry, over 70% citizens of this country, were removed from the West Coast and detained at so-called war relocation centers in 10 different permanent camps for nearly 3 years. But to put this in context, and so that we don't think that this was just an isolated incident, I bring a few things to your attention. You have to put yourself back in the 1940s. And this was a time when immigration of Japanese Americans, Asians had been ended. Japanese Americans were not allowed to become naturalized citizens. The Issei, the first generation, were not permitted to own land. Some states prohibited interracial marriage. There were restrictive covenants that prevented people from selling land to Japanese Americans. And if you recall, in the South, this was still a time when Plessy versus Ferguson was in effect, and it was a segregated South. Also, military units were segregated by race. So that was sort of the historic context. General John L. DeWitt, unfortunately, was the commander of the Western Defense Command who issued the orders. Some of his comments included something that Japanese Americans remember: a Jap's a Jap. Japanese race is an enemy race. Doesn't matter whether he's a citizen. So as a result, there was the internment of Japanese Americans. There were 3 individuals who tested the military orders: Fred Korematsu, Minya Sui, and Gordon Hirabayashi. And we'll be focusing primarily on the Fred Korematsu case, but there will be references to the other cases as well. Now you have to fast forward several decades, think back to the civil rights movement, to the anti-war movement, and the student movement. And out of the student movement, there was a big strike at San Francisco State that resulted in the creation of the Ethnic Studies program. The first dean of the Ethnic Studies program was James Hirabayashi, who was interned at the Pinedale Assembly Center. One of the teachers at San Francisco State was Edison Uno, and in 1970 he approached the Japanese American Citizens League to seek reparations for the internment of Japanese Americans. It took 2 decades before payments were actually made. In the interim, and before the passage of the Civil Liberties Act in 1988, a congressional commission was created, the Commission on Wartime Relocation and Internment of Civilians. And in 1982, the commission issued its report that there was no military necessity for the internment of Japanese Americans. No Japanese American was ever charged, let alone tried, for espionage or sabotage, which is a basis for the military orders. And then in 1984, these forum notice cases were decided, at least in the Fred Korematsu case, and resulted in vindication of the Japanese American community. Fred Korematsu was convicted, and his criminal conviction was vacated as a result of the Coram Nobis case that 3 of these fine people helped bring about. So if you think back, this is a story about the failure of every branch of our government, including the general population that supported the internment of Japanese Americans. And by the end of the story, all 3 executive branches had acknowledged that a wrong was done. And this is part of an education program to get the story out to the general public as well. At this point, I will turn over the floor to Karen Kai, who will say something about the litigants themselves. Karen, is that mic working? If not, you can use this one.
Is this working? Yes, great. Look, Dale, thank you very much for that very decorative introduction. You might have to invite us back to Fresno again, to get it right, coming back. And it really is a pleasure to be here and to be invited by the library to be here in this beautiful art museum, and to have such a wonderful and enthusiastic and large audience. It's so important to have these stories continue to live, because they are part of that search for democracy that is central to the program that's going on this summer. And it should be ongoing for our society and our communities. And
I say these are stories because what happens to us as human beings are human stories. And as we litigated these cases, and lawyers, we tend to get this idea of cases and laws, and it gets very dry. But we were so fortunate that we dealt with 3 very extraordinary people as petitioners in this case. And back in the 1940s, these 3 men were very distinctly different people from one another. Min Yasui, who was probably, I think, the oldest of the 3, I believe he was around 27, was the son of a prominent family from Hood River, Oregon. He was a fireball. He was ambitious, articulate, capable, unstoppable. He was one of the first Nisei to become an attorney, to get that law degree, but he couldn't get a job. So he went to Chicago. Through family connections, he was able to be employed by the consulate, the Japanese consulate in Chicago, where he did some ministerial things. He was very handy because he could speak both Japanese and English fluently. Well, with the outbreak of the war, of course, he came back to Oregon to be with and to support his family. But because of his legal training, because of his deep belief as an American that he was entitled to certain rights under our Constitution, he could not abide the orders that were coming down from the military to the Japanese American community. And he set out virtually immediately upon the issuance of those orders to violate them. He wanted to be the test case. He was going to hit the streets, be an activist, and change this law. Well, the rest of the society was not quite up to speed with Min. He had to track down a policeman, asked him, please arrest me. Look, I'm Japanese American. Here's my birth certificate. It's after 8 o'clock. I'm violating curfew. And he was told, young man, go home, you're going to get into trouble. He was not daunted. He went to the police station and demanded that he be arrested. And he was. And that was the start of his legal journey. Gordon Hirabayashi was a student at the University of Washington. And Gordon was very philosophical. He was very studious and a very, very deep thinker. And he was also very much involved with the Quaker house up in the university. And it bothered him, again, that his rights were being violated, and that he had actually been thinking that there was this possibility of war, and if there was a draft, a military draft, he would have to be a conscientious objector because of his religious beliefs. And so as these orders started to come down from the military upon his community, he said, this is not right. Someone needs to do something. I will stand up. I will be the one to do this. He kept a diary, a log of his curfew violations. And it occurred to him that, my friends who are Caucasian get to stay out and study at the University of Library, and they're hustling me home so that I don't miss curfew. This isn't right. And eventually he got to the point where, after talking with some of his friends, he said, yeah, this is the time I'm going to do this because I cannot allow myself to be part of a system that violates the rights that are set forth in the Constitution. And he went with Floyd Schmo, a very prominent Quaker member in the community, to the FBI and turned himself in. Fred Korematsu was 23 years old, a young man, kind of searching for himself. And he had a job as a welder. He really wanted to stay in the Bay Area, do his part for the war effort, but he was also in love. And he had a young lady that he wanted to marry, and he had hoped that they could, at the time there was a possibility of voluntarily removing yourself from the military zones. And his goal was that they would save up enough money that they could then move inland and avoid any of the required actions against Japanese Americans. But time and fundraising didn't quite keep pace, and he was left. He had to decide, do I go into one of these assembly detention centers and leave my life, or do I try to make it on the outside? And he decided to try to pass, and he had a rather unsuccessful eye surgery to look more or less Japanese. And he was eventually apprehended, and he kind of had the sense, as he was doing all of this, that this was not a right thing to happen to an American citizen. It was after he met Ernest Bessig, an attorney from the ACLU, who was looking for a plaintiff to challenge the internment, that he really started thinking, and he became more and more and more committed to this idea that he could be one of the people that made a change for the better for all of his family and his friends. And it was a very difficult road because most of his family and friends didn't want to hear that someone was resisting these orders. They wanted, you know, go along. It will be easier on everyone if you do that. Just, you don't need to do this. But he was resolute, and he said, I'm going to do this. These three men took their cases all the way up to the Supreme Court with great hope in their hearts, with faith in their attorneys who worked and did incredible work in that regard, and they lost in the U.S. Supreme Court. And for 40 years after that, they lived with that. Gordon, very philosophical. And one thing too, Dale mentioned Jim Hirabayashi, having been here at Pinedale, and he's in one of the photographs. And Jim Hirabayashi was Gordon's younger brother. So the family stories kind of start to relate here too. Gordon became a professor of sociology, and he taught his students about the internment, and he was always trying to develop ways to teach and to teach the lessons of what happened to him. Nin Yasui continued to be a lawyer. He became a very prominent lawyer in Denver, served on the Human Rights Commission, very, very active in JACL. And he became an advocate that there must be something done to reverse and erase this mark on our American Constitution that came about because of the internment of Japanese Americans. Fred Korematsu lived very quietly in San Leandro as a craftsman, community member, raised a family, and always wished that there was some way to reopen his case. And we were very fortunate in the early 80s to have that opportunity, and I know other people get to tell that story. But this gives you a little idea of who these men were, because even though they started out very distinctly different personalities, the one thing that tied them together was this search for justice, for democracy, that kept burning in them for 40 years and beyond the Coram Nobis case.
Thank you very much. Karen mentioned the importance of the ACLU, and Bill Simon is here to represent the ACLU. I should have included him in the initial introduction. apologize for that, Bill. But Bill helped found the Fresno area chapter of the American Civil Liberties Union in Northern California and served as its chair from 2007 to 2010. And so I'll have Bill start and then Bob participate in discussion of the Korematsu case before the Supreme Court and any of the other cases that they've heard. Bill?
When I told the staff at the ACLU of Northern California about this program and that the Fresno chapter intended to participate, they were extremely enthusiastic because after all these years, the ACLU of Northern California is still very proud of their early involvement with Japanese internment and with the Fred Korematsu case. As Karen said, Ernest Bessig was the director of the ACLU of Northern California at the time. He visited Fred at the Oakland jail, and in July of 1944 he went up to Tule Lake, the internment camp, and discovered that there were 100 men locked up in a concrete stockade without any connection with the outside world. He got kicked out after 2 days. But when he came back to San Francisco, he hired Wayne Collins to get the men out of the stockade. And Wayne drove the 400 miles to Tule Lake and threatened to file for habeas corpus, and the men were released into the regular camp population. In a lot of ways, as I read about Wayne Collins, I began to realize that he's really a hero in this whole thing. Not only did he get them released from the stockade, but he went on to represent Fred Korematsu. And then he took on the case of restoring citizenship to Japanese who had renounced their citizenship under pressure when they were in the camps. And then he took on the case of Japanese Peruvians who had ended up in this country during the war, and now our government wanted to deport them, but Peru wouldn't take them back, and Japan was in a shambles. So Wayne Collins successfully spent decades arguing that they should be able to stay here. In Southern California, A.L. Weirin of the ACLU of Southern California was involved in the Ernest Wakayama case, and even Professor Peter Irons, who finally discovered evidence of government misconduct that finally led to resolution of the whole situation, served 2 terms on the board of the National ACLU. So the ACLU has been there trying to defend the constitutional rights of everyone, and especially in this case, our Japanese brothers and sisters.
Hello, everyone. Thank you for being here. I've been asked to speak about the Supreme Court decisions or the cases, the wartime cases, and what happened to them. As Karen has already indicated, these 3 men, young men, just in their early 20s, Min was the oldest, still in his 20s, decided to take on the United States government because of their deeply held belief that as Americans, they could not go along with being subjected to orders that would discriminate against them because of their ancestry without essentially impugning an entire people, entire communities up and down the West Coast, over 120,000 people, implicitly branded with disloyalty or the potential of disloyalty, sufficiently worrisome to forcibly remove them from their homes and communities on the West Coast, and eventually to in turn incarcerate them in desolate concentration camps or internment camps, or mostly in the interior of the West Coast, but as far east as Arkansas. These 3 men stood alone. They had very little support. As Karen mentioned, Gordon Hirabayashi had support from the Quakers up in Seattle, and Fred Korematsu here in the Bay Area found support, or his support found him in the person of Ernie Bessett, who came to visit him in jail and asked him whether he would be interested in being the test case to challenge the constitutionality of the military orders that were starting with a curfew and then excluding people from the western parts of the United States, designated military zones by the commander, and eventually to be interned in these camps because essentially they had nowhere else to go. Karen's already mentioned what happened to their hopes in challenging these. Let me back up a minute. As Dale mentioned, Congress made the violation of these military orders a crime, a federal misdemeanor. And all three of these men were very quickly convicted of violating these military orders. All that needed to be proven is that they were of Japanese ancestry, which was not disputed, and that they either stayed out past the curfew, did not report to the to register for the assembly centers, or did not leave the area. There are hopes that the Supreme Court would hear their pleas that military orders that discriminated on the basis of national origin could not be sustainable under the United States constitutional freedoms was dashed. All three lost at the Supreme Court. Dale mentioned we wanted to focus on the Korematsu case, but you really can't focus on Korematsu without talking about Hirabayashi first. Law is nothing if not procedure in many ways. Gordon Hirabayashi's and Min Yasui's cases reached the Supreme Court first in April, and the decisions were in April of 1943. So they reached the court in early 1943. In Gordon's case, he had been convicted of two violations, curfew violation and failing to report. He was convicted and served two concurrent 3-month, 90-day sentences. He did that because he basically wanted to be eligible for work furlough instead of sitting in a prison, and he had to have a longer prison sentence to do that. That came back to haunt him, because when it reached the Supreme Court said, well, we have two concurrent sentences, we only have to address one of them. If we affirm one of them, the curfew violation, we don't even have to look at the other one. And that's exactly what they did. One of the most striking things about the Hirabayashi decision, the first major decision to come down, is although it was a unanimous decision from the Supreme Court, is the tentativeness and timidity of the court's decision. It relied heavily on an expansive definition of the war powers. Not surprising when the U.S. was in the midst of two wars at the time, both in Europe and the Pacific, and essentially held that whatever the executive and Congress wanted to do in furtherance of their responsibilities to wage war and defend the country, the court was essentially not going to stand in the way. The court refused to look at the large picture, the internment of 120,000 people for what appeared to be the duration of the war. Instead, as I already indicated, they split the case up and looked only at the curfew violation, deciding that that was, in Gordon's case, a hardship, one of the hardships that we all had to bear in being part of a nation at war, and that the curfew fell within the discretion of the authority having been delegated to the military commander, starting with the president's, Roosevelt's executive order, and then down through the administrative chain. So the court adopted a posture of extreme deference to the military commander's decisions and the executive's decisions, that actions were necessary in order to protect the United States. It gave lip service, important lip service as it turned out historically, to the notion that they were also dealing with a fundamental deprivation of civil liberties. In the Hirabayashi case, the court wrote that discrimination on the basis of race is odious to a free people, and under any other circumstances would not be countenanced. But it went on to say that in times of emergency and war, that it was permissible, and on that basis upheld the curfew. What evidence did they look at? Very little, because there was no specific evidence of any disloyalty, let alone widespread disloyalty among the Japanese American population. So they looked at general factors that amounted to basically racial prejudice. Factors like there were fifth columns in Europe. There were facilities on the West Coast that Japanese Americans may have lived in. Ironically, racial discrimination, historic racial discrimination through the first 40 or 50 years of the 40 years of the 20th century had isolated the Japanese American community. Some of them went to language schools. Some Japan regarded even the Nisei born here as having dual citizenship. All these are just generalized definitions of characteristics that the Japanese American population had. And it was on this basis, these sort of factors, that the court decided in double negative, saying we cannot say that suspicion of the Japanese American population was unfounded. There was no finding that there was any threat from the population. The court simply said we cannot say it was not there. Min Yasui's case was mentioned quickly. It was a companion of Gordon's, and the court simply upheld Min's conviction on the basis of what its reasoning in Gordon Hirabayashi's case. One of the interesting twists in Min's case is that at the trial court level, the federal district court, the district court judge actually held that the military orders were unconstitutional as applied to citizens. And he was ready to hold that. But then he decided that the mere fact that Min worked for the Japanese consulate in Chicago doing the ministerial tasks that Karen mentioned was amounted to a renunciation of the citizenship. And on that basis, upheld the conviction. The Supreme Court simply said, well, these are constitutional even as applied to citizens, so we still affirm the conviction in Min's case. A year and a half later, in December 1944, Fred Korematsu's case, because of procedural reasons, came before the court. This time the court was not unanimous. It was a 6-3 decision. It was 3 stinging dissents from 3 of the justices, Justice Roberts, Justice Murphy, and Justice Jackson. The majority decision, written by Justice Black, no stranger to civil liberties later on, simply, even though that they were dealing with a more serious infringement on civil liberties, the failure to leave the area, failure to obey the exclusion orders, simply adopted the rationale in the Hirabayashi case, which was dealing with curfew, to say, well, the same reasoning justifies the exclusion orders. So we don't need to look any further. The court denied that the case really had anything to do with race, but simply was about a threat posed by a population to the security of the United States. The dissents, very briefly, Justice Murphy attacked the racial discrimination head on and said that the decisions that the court was upheld fell into the abyss of racism that the United States Constitution would not allow. Justice Jackson agreed with Justice Murphy, but also raised the issue that really haunts these cases and continues on to the Quorum Novus cases, and that is, what are the checks in a democracy on power? As we've always grown up hearing the phrase now and again that power comes out of the barrel of a gun, and for most of human history that's been so true, whether it's a gun or it's bow and arrow. In a democracy is very much, it depends on people committing themselves to upholding these freedoms. And the court playing a role in that, if these freedoms are to survive the threat posed by the power that is held by the military and by executives who control the military. And that's an issue that obsessed Jackson throughout his career, and obsessed him in this case as well. And I'll stop there and segue by saying that this is the issue that lies at the heart of the quorum nobis cases that were brought 40 years later.
Roberta, how are we doing on the audio?
Ready whenever you are.
Okay, let me just say that our, you want to introduce it?
No, it's all right.
Yes. Okay, the next segment is the basis for the quorum nobis cases, the fact that the government suppressed evidence. And Bill had mentioned Professor Peter Irons. So what you're going to hear now is something from Professor Irons' great lecture series on the history of the Supreme Court and what he discovered in researching the book. So with that set up, Roberta, hit it.
Let me share with you my own involvement in this effort, which began in 1981. I was working on a book about the internment cases called Justice at War. Justice Department officials finally gave me access to their records in these cases. The files were stored in several dusty cardboard boxes tied with string and hadn't been opened in 30 years. When I opened the first box on the Hirabayashi case, I found a document that literally shocked me. It was a memorandum from a Justice Department lawyer named Edward Ennis to Solicitor General Charles Fagan, dated April 30th of 1943. Ennis was preparing the Supreme Court brief in the Hirabayashi case, and he had discovered military intelligence reports advising General DeWitt that mass evacuation of Japanese Americans was not necessary. Ennis urged Fagan to inform the Supreme Court of these reports, warning him that any other course of conduct might approximate the suppression of evidence. But Fagan ignored this warning and told the court that mass evacuation had been the only means of protecting the West Coast against sabotage and espionage by Japanese Americans. I also found in these records a memo from Ennis to Fagan in the Korematsu file, dated September 30th of 1944. Ennis had discovered military intelligence reports that flatly contradicted the claims in General DeWitt's final report of radio signaling to Japanese submarines off the coast. Ennis urged Fagan not to submit DeWitt's report to the court. He wrote, "It is highly unfair to this racial minority that these lies put out in an official publication go uncorrected." But the Solicitor General again ignored Ennis's warning. As we saw, Fagan assured the court that he stood behind the accuracy of DeWitt's espionage claims, and the court accepted them in its Hirabayashi and Korematsu decision. Now, suppressing evidence and telling lies to the Supreme Court are serious offenses. As a lawyer, I knew that proof of governmental misconduct would allow federal judges to reverse criminal convictions, even when the defendants had served their sentences. I contacted Gordon Hirabayashi, Min Yasui, and Fred Korematsu, who were now in their 60s. All three men accepted my offer of legal help in bringing their cases back to court. And I recruited a team of some 30 young lawyers and law students, most of them the children of Japanese Americans who had been confined in internment camps.
All right, Don will take it from there.
Well, I have the fun part of the evening because my this next section reads a little bit like a movie script. You know, my parents and families here, I'm sure, when people were taken away and removed, they wondered what was going to happen to them, and after it was over, I think people more or less viewed it as a product of wartime hysteria. You know, America was under great pressure, Japan had attacked, and in the beginning of the war, the United States was losing their war. And as a result, people reacted. What we found, and what Peter found, is quite by accident in researching government archives, that perhaps what began as wartime hysteria, as emotional decisions, ended ultimately in an intentional plan to manipulate the outcome of these historic cases, even if it meant lying to the United States Supreme Court. And so I can recall when talking to my parents before we filed, we had a sheaf of these documents that Peter had found, and it was jaw-dropping for them, because they had understood that it was a great wrong, but they didn't realize how great a wrong it was. And in fact, when Peter showed Fred these documents, Fred looked at them page by page, and these are Justice Department memos. They're writing to each other about what their ethical obligations are, and the fact that they ought not to be lying to the United States Supreme Court. And Fred looked up, and his response was, "They've done me a great wrong." And on that basis, basically, governmental misconduct, we reopened these cases. In defending against the challenges of Korematsu, Hirabayashi, and Yasui, the government essentially had two defenses. One, that Japanese Americans were committing acts of espionage and sabotage by signaling enemy ships from shore, resulting in sunken boats. This is shore-to-ship transmissions. That was one claim. And the other claim the Army had made was that Japanese Americans are prone to disloyalty. As Bob was saying, they're so different. They speak another language. They worship a different god. They are unassimilated and unassimilable, which is kind of a recurring theme in American history, especially on the West Coast. That they cannot be American, and therefore they're prone to disloyalty. And so when these cases began working their way up, remember, Japan attacked Pearl Harbor in December 7th, 1941. By March, the roundup had begun in March of 1942. By the summer of 1942, we had 110,000 Americans of Japanese ancestry who lost their property, lost their freedom, some had lost their lives, and they had been removed to 10 internment camps located from California to Arkansas. And another year passes. It's 43 by the time Hirabayashi and Yasui's case comes up, and then 44 finally by Korematsu. So by the time these cases get to the Supreme Court, it's a fait accompli. I mean, it has happened. And now the court is reviewing, whether it was justified or not. And the Army, again, had said, yes, it was. It was a, quote, military necessity. And so in figuring out that, Edward Ennis, who was responsible for drafting the government's defense in these cases, and Attorney General Francis Baird, the #1 legal officer, he was the Eric Holder of his day, basically began assembling, the evidence, and expecting to find, evidence of wrongdoing on the part of Japanese Americans. And so Francis Biddle writes to J. Edgar Hoover, the FBI, and he said, "Show me your ship-to-shore transmission evidence." And Hoover writes back and he says, quote, "Every complaint that Japanese Americans have been engaged in espionage has been thoroughly investigated, but in no case had any information been obtained that would substantiate the allegations that there has been illicit signaling from shore to ship from the beginning of the war." So Biddle is concerned, that doesn't sound right. So then he writes to the chair of the Federal Communications Commission, which has complete jurisdiction over the airways. And so he writes to Sterling, and the FCC chair writes back about his meeting with General DeWitt. And he said, quote, "The general launched into quite a discourse about radio transmitters operated by enemy agents in California, sending messages to ships at sea. Since General DeWitt seemed concerned and in fact seemed to believe that the woods were full of jabs with transmitters, I proceeded to tell him and his staff the organization of the FCC monitoring program. I know it virtually astounded the General Staff officers. Frankly, I have never seen an organization that was so hopeless to cope with radio intelligence requirements. The personnel is unskilled and untrained. Most are privates who can only read 10 words a minute. They know nothing about signal propagation, wave propagation, or other technical subjects so essential to radio intelligence procedures. They take bearings with loop equipment on Japanese stations in Tokyo and report to their commanding officer that they have fixes on Japs with transmitters operating on the West Coast. These officers, knowing no better, pass it on to the general, and he takes their word for it. It's pathetic, to say the least, unquote. So now Ennis and Biddle are really alarmed because they are about to present their case before the Supreme Court, again, the arguing that, hey, this was a military necessity. There was a good reason to lock up all these people. And so Ennis enlists a guy named John Berlin. He's an assistant Justice Department lawyer. And so Berling writes to Assistant Attorney General Herbert Wexler. He says, quote, "You will recall that General DeWitt's report," this is the Army claims of wrongdoing, "makes the statements concerning radio transmitters and ship-to-shore signaling, which are categorically denied by the FBI and the FCC. There is no doubt that these statements are intentional falsehoods." So now they're really alarmed, okay? And so there's no evidence of any wrongdoing. As Dale said, no one was ever charged, let alone tried and convicted of espionage. And now the cases are before the Supreme Court. So Ennis writes to, again, to Wexler, again, and he says, quote, "The general tenor of the final report, which was ultimately submitted to the U.S. Supreme Court, has the reasons for the internment. He said the general tenor of that report is not only that there was a reason to be apprehensive, but also to the effect that overt acts of treason were being committed. Since this is not so, it is highly unfair to this racial minority that these lies put out in official publication go uncorrected." And so, but they're not getting any traction in the Justice Department. And so he writes to the Solicitor General of the United States. This is the lawyer that argues before the U.S. Supreme Court. His name is Charles Fahey. And so Ennis writes to Fahey talking about a naval intelligence report that said basically two things. That there is no reason to intern these people. And it should be handled, the so-called Japanese-American problem should be handled no differently than the Italian-American or the German-American populations. And it went on to recommend against internment. And the Navy had the official jurisdiction over national security concerning Japanese-Americans. And so Ennis writes to Fahey and he says, "I think we should consider very carefully whether we have a duty to advise the court of the existence of the Naval Intelligence Report. It occurs to me that any other course of conduct might approximate the suppression of evidence." And so, no traction, he's not getting anywhere. So he writes, so Berling and Ennis get together and they write a footnote in the Cormant's brief. And the footnote doesn't say something like, you know, we have an FBI report, SEC reports, military intelligence reports that contradict what the general is saying. It basically says that, you know what, the general's saying this, but we have reports that are in conflict with what the Army is saying. That's all. Okay. But it's kind of a red flag, like, we're not real comfortable with this, and we don't want to be accused of lying. So the brief goes to print. They printed briefs then and now. And the Solicitor General Fahey finds out about the footnote. He literally orders the printing press to stop. He orders the footnote to be rewritten. And the footnote ultimately read, you know, we have in our possession reports that we're relying on in making, you know, and arguing our position. And so the last attempt really to alert the Supreme Court that something was wrong failed. These are just basically a handful of, just to give you flavor of these documents that we're looking at. It was a lawyer's dream. You know, you never get smoking gun evidence like this. I think the other question from a philosophical standpoint is what happens to democracy when the people who are sworn to tell the truth and uphold it engage in just the opposite, and that is not letting the facts get in the way, even if it meant lying to the U.S. Supreme Court, in order to uphold and cover up, you know, what really happened. And so, you know, this case is so remarkable in so many ways. I mean, of course, the tragedy of Americans' Japanese ancestors being interned, but the ultimate subversion of democracy at the highest levels. I mean, we're not talking about something low level.
This is probably the driest part of the program. Having discovered this evidence, Peter having discovered this evidence, the Office of Naval Intelligence report, which had been as a result of the ONI's surveillance of the Japanese American community even before the war, and the FCC and FBI reports which refuted entirely the claims being made by the Army active espionage and sabotage was going on. What do we do with this evidence? We have cases that are 40 years old, petitioners are in their 60s. Any sentences they had long been served. The cases were over. This is just history that we were dealing with. But these documents show, and there's still more to come actually, but even the initial documents showed that basically a massive fraud had been perpetrated on the Supreme Court. I say that with a little bit of a reservation because the Supreme Court's own extreme deference, the decision it made in reviewing these cases, was its own acts of complicity in ultimately allowing what happened. But there is no question but that the cases that were presented to the court for decision were knowingly manipulated in a way that perverted the truth-finding purpose of the judicial branch of government. We filed in federal court what is called a writ of error quorum nobis. What's that? Very simply, best I can. It's an ancient common law writ that comes out of Anglo-Saxon law that survives in modern American practice in criminal law, not civil law, which allows the court to correct its own errors, own factual errors, based upon evidence brought to it that shows that there was a fundamental miscarriage of justice, usually one that implicates the integrity of the judicial process itself. It's not just any error, but errors of fundamental character. And if there was ever an error of fundamental character, this was it. Don mentioned that we were all very young attorneys. We were out of law school only a couple of years and really didn't know much of anything, which probably was to our benefit, because had we known how much work this was going to be and how it would consume our lives for the next 10 years, we would be probably much more reticent about taking it on, or have to be much more candid with our supervisors and the firms we work with about how much work it was going to be. But fortunately, we had what Dale Manami called the wisdom of fools, and we proceeded anyway. The writ substantively, as I said, attaches when there's been fundamental miscarriage of justice that perverts the judicial process. In that sense, it is very similar to habeas corpus. The major difference is that in habeas corpus, there is some sort of custody, either someone in jail, classic form of custody, or even an expanded definition of custody, like probation law, where there is some sort of restraint from the government. habeas corpus will lie for that. When the sentence is completely served, however, and there's been, at least in federal court, and when there's a sufficient miscarriage of justice, this ancient writ still survives, according to the U.S. Supreme Court, to address that wrong, not only for the individuals, but for the integrity of the process itself. And that is what we were proceeded on, to use something that none of us had ever heard of before, to correct a fundamental historical injustice on an important part of America, but also on the very concept of how a democracy needs to work if it's going to, that fragile thing, if it's going to survive. Donna, do you want to pick up?
So we tailored a political public information relations strategy along with the legal strategy. And a couple reasons for that. I mean, most of the time, lawyers are not supposed to try their cases in the press and before the public. They're supposed to do it in a courtroom in front of a judge like but the fact of the matter is, these three litigants, they'd already done their time. You don't get any money out of this in the writ of error coram nobis, so it's a device to clear your reputation. But in their heads, I mean, this really symbolically amounted to the trials that Japanese Americans never had, right? Nobody ever was tried. They didn't get their day in court, basically. And so that was one reality that we needed to get the information out there. And it's flabbergasting, it's stunning that you had people willing to lie before the Supreme Court on such a major case. I think the second thing is there was no assurance that we would win. I mean, we hated the idea of being going down in history as lawyers who lost the Korematsu case for the second time. That was a distinct possibility. You never know how a court would view it, how the evidence would come out. We didn't know what the government had. And so basically, win or lose, we were going to try to provide education and a new chapter in American history on what really happened in 1942 to 44. And so win or lose, we were going to get that story out. And so, Fred, extremely shy person, he said, I don't want to talk to the press. And in fact, when he was first arrested, he was vilified. It was like Jap spy arrested in San Leandro. And then he was brought before the court in handcuffs, in shackles, basically. It was a bad experience. And so, he moved on. He was very active in the Lions Club. His employer didn't know anything about this. And we said, Fred, don't worry, the lawyers will talk for you. You don't ever have to talk to the press. But when we filed, it was top to bottom press, from the Washington Post, New York Times, Network News, CNN, 60 Minutes, cameras parked out in front of Fred's lawn. And so, because it was explosive information of fraud on a major case. And, but at the same time, when Fred got his story out, it was quite cathartic. That suddenly he went from go to hero. As Peter describes it in a sort of perverse way, he took his case all the way up to the Supreme Court. He lost. And so he felt almost a sense of responsibility for that. And so he didn't have to, and he took a stand, and he got punished for it. So price of freedom is not cheap, and for him, it was a lifetime of trying to live that down. He never told his kids about it. And so they only learned just, when Peter began disclosing this information. And so, long story short, I mean, our goal was really to educate the public and rewrite the history on these important cases.
Thank you. We have a video clip for you. As mentioned, Don was a strategist for the Public Outreach and Education Program. You'll see Don and Dale Manami, who is the lead counsel, as well as the three litigants, Fred Korematsu, Minya Sui, and Gordon Harabayashi. coming up. So, Roberta, hit it.
The cases of 3 Japanese Americans convicted for refusing to be evacuated or interned during the war bolsters the campaign for redress in 1983. Fred Korematsu, Minoru Yasui, and Gordon Hirabayashi sued the government to have their convictions overturned. Their legal team discovers suppressed evidence that the roundup was not necessary. Attorney Peter Irons researched the cases.
What wasn't being made public was the government's knowledge that there was evidence that completely exonerated Japanese Americans from all the charges that they had committed, espionage and sabotage. It's quite clear that the evacuation was based on racial stereotypes alone, that there was no military need for the evacuation. So in that sense, it shouldn't have happened.
Now being an old man and a little realistic, again I'm infused with that feeling that right will prevail.
The defiant Minoru Yasui dies in 1986 before he could realize the courts finally cleared his record. Korematsu and Hirabayashi also won their cases. Frail and hampered by arthritis, Mary Tsukamoto has emerged as a driving force behind the redress movement. It is Mary's voice that guides visitors through an exhibit on the relocation experience at the Smithsonian Institution. As the co-author of a book on internment and a retired educator, she wants America's young people to learn from the mistakes of the past.
But I'm challenging the future generations to come in this country that we're going to have to be forever vigilant and prevent this kind of thing from happening to anybody else.
The injustices of the past help the next generation better understand their parents.
I think I've gained a better understanding of my parents and the Nisei generation, an understanding of how much this has tormented them over the years, how much energy they had to put into suppressing what they felt, how much they had to almost forget the depth and scope of the injustice done to them. And I see all these emotions coming out now. I see them talking more openly. I see them laughing, crying, dealing with the camps on a real human level.
Thank you. It took a lot of courage for these attorneys to take on this important case. You saw Dale Manabe there, and he sort of exemplifies the courage and perseverance of those attorneys. He wanted to be here, but he has 2 young children, one born within the last year, so brave guy. Take that on in the 60s. So. Anyway, we'll go on to the outcome of the litigation and turn it over to Don and Karen to say what happened.
Okay. So on the Korematsu case, oh, I see. Yeah, you're back. See. So on the Korematsu case, we filed in 1983, and the strength of the case was really nothing that we said. The strength of the case was based on the government's own documents. And along with our petition, we had an exhibit of about, it was like 1.5 inches thick of Justice Department memos. These were memos written from one lawyer to the other, from the Attorney General, from the Solicitor General. And so, we were wondering, okay, how is the government going to refute their own memorandum admitting that they were falsifying evidence, in some cases burning. We found one instance where literally the initial report, which contradicted the position that the government wanted to take, was burned, and a new one rewritten in a way that would be consistent, and no one was to know of the original. And so we later, after a number of court hearings, one after the other, the government just couldn't come together with a coherent response. And Victor Stone, who was a U.S. Justice Department lawyer assigned from Washington, D.C., basically at every court appearance said to Judge Patel, "We need more time, Your Honor, we need more time." And he said, we understand that there's an official report on the internment coming out, and we think in there'll be the real reasons that justify the government's position. Well, October rolled around, the report came out, and the title of the report was Personal Justice Denied. And so the judge looked at him and said, well, that doesn't sound like it's going to support us. And so he says, what are you going to do? You're supposed to file a response within, 30 or 60 days of the petition. Now it's months later. And he says, well, I'm waiting for a direction from my superiors. And he says, well, who is that? And he explained so-and-so. Well, when can you talk to them? And he says, well, we're trying to get a hold of them, and so on. And she says, I want you to call him right now. This is in San Francisco. And he's calling back to Washington, D.C. So he disappears out of the courtroom, and this is October, and comes back, and he says, well, Your Honor, I'm sorry, we just don't have a response. And so Judge Patel said, well, I'm ruling against you. And basically defaulted the government out. And she called it a confession of error. That inaction and stalling amounted to an admission of wrongdoing on the part of the government of misconduct. And then she later issued a written decision and made findings that the foundation upon which the historic Korematsu versus the United States is based upon falsified facts. And I'll just quote one line in her decision that I think is interesting. She says, Korematsu remains on the pages of our legal and political history. As legal precedent, it is now recognized as having very limited applications. As historical precedent, it stands as a constant caution that in times of war or declared military necessity, our institutions must be vigilant in protecting our constitutional guarantees. It stands as a caution that in times of distress, the shield of military necessity and national security must not be used to protect governmental actions from close scrutiny and accountability. It stands as a caution that in times of international hostility and antagonisms, our institutions, legislative, executive, and judicial, must be prepared to protect all of our citizens from the petty fears and prejudices that are so easily aroused, unquote. It was really a prescient statement because, regrettably, what she's saying is more relevant now than it was in 1983. And so the government initially appealed, and then they withdrew their appeal. So in our system, winners can't appeal. If you win your case, you can't appeal. So strategically, what the government did was to keep Korematsu at a trial court level. And so it never got up to the Court of Appeals and ultimately to the U.S. Supreme Court. So the result of it is Korematsu has not been reversed. Only the Supreme Court can reverse itself. But the precedent itself has been badly discredited because every Supreme Court precedent is supposed to rest on a foundation of true facts. And you have a lower court basically saying, well, the court issued this historic ruling, but on facts that didn't exist.
And of course, we had something of a wily legal team, or actually 3 legal teams, because under the court rules, we had to file these quorum nobis petitions in the original courts for each person. And there were 3 courts. So we ended up dividing into 3 legal teams, 1 for each person. And so this gave us 3 bites at the apple. This was our hope that if one went down, we'd still have 2 more opportunities. Well, you can imagine after our first time up to bat, home run. Well, this is great. This sets a precedent that the other 2 courts can follow. And so as we head towards Oregon and Masui's case, which is the next one up, the government holds a very interesting strategy. They say, we'll vacate the conviction. We will move the court to vacate this conviction. So there's no need to decide on this quorum nobis petition. So let's just go that way. They filed the same petition or same motion in Gordon Hirabayashi's case. Well, judges are important. And so when a good judge, a hard-working judge, is really to be treasured. And that's why we love him. But, you know, Judge Patel is one of those classic, hard-working judges, extremely bright, very conscientious, and she actually confessed later that when this petition rolled across her desk, she didn't know what a writ of error quorum nobis was either and had to look it up. But when she didn't just say, oh, here's what it says in Black's Law Dictionary. She says, what's the implication of this? What does this mean that I should be doing as a judge? And she took the responsibility of that motion, of looking at error before the court, fraud by the government, misleading the court into doing something wrong, and very seriously addressed it. We were not so fortunate in Oregon. In Oregon, the court really did not seem to want to deal with this. They looked at the government's motion as an easy way out. Motion granted, go home, enjoy yourself. Well, as you can see from that video clip, that was not going to satisfy Min Yasui, who was now on fire and saying, that was not what I came here for. I want to be vindicated on the reason that we're here, on the government misconduct, and I want to set this record straight. And one of the biggest disappointments, I think, for all of us was that Min passed away before we could complete an appeal from that decision, essentially in his favor, although on the government's motion, because he wanted to pursue it. And we did appeal to the Ninth Circuit, where his legal team did, and it was only because of his passing that I think we would have gone up all the way as far as we could. But that left Gordon Hirabayashi's case. And Gordon's case was before another hardworking, intelligent, dedicated judge, Donald Voorhees. And Judge Voorhees said, no, it's not sufficient to just vacate this conviction. In fact, I want a hearing on the merits. We are going to trial. And this was like everyone sat up and like, oh wow. And all the records were going to come forward. This was really the trial that we had all hoped for, and it had all the trappings, the ability to depose witnesses and have testimony before the courts. And it was really a shock to us that the government's case was a shambles. But we thought they'd have something. They brought up boxes and boxes and boxes of paper and rambled before the court to the point where the judge said, counsel, show me your best piece of evidence, and I'm going to rule on whether you can continue to put these papers before this court. And the attorney rifled through his boxes and pulls out a paper and says, all right, Your Honor, here it is. In England, in 19-something, a Scotsman, and this starts to sound like a Shaggy Dog story. And the judge is looking like, counsel, does this really have anything to do? And the Justice Department Attorney, Victor Stone, is trying to explain this, and the judge says, counsel, I am not going to admit your documents into evidence. And that was really a blow for the government. And we went forward primarily on witnesses. Peter Irons was a key witness. Gordon testified in that case as well. We also had two outstanding experts on the documents, the work in the archives. Jack Herzig, who was a retired military intelligence officer, testified on the issue of the magic cables. Did the U.S. have information that broke the Japanese codes that could then have intercepted a lot of the military documents that were going back and forth, and was there a knowledge, therefore, that there were Japanese Americans involved, people involved. And the key witness, and she's quoted in the decision by Judge Boyce, was Eiko Herzig. And Eiko Yoshinaga Herzig was an archivist. I mean, when do archivists get to be the star witness in Gordon Hirabayashi's case? So librarians, this one's for you. Eiko was able to create that paper trail showing the government misconduct so clearly, with such candor, that there was no refuting what had gone on. And it's a rare skill, and Eiko was, Peggy Nagai, who was Nin Yasui's lead counsel, and I had the real honor and pleasure of being the ones to prep Eiko for her testimony. And we just kept saying to her, Eiko, be yourself, tell your story, because it's all there. And that's exactly what she did. And by presenting these documents, the court said, okay, we've got a reason here to rule, we've got real evidence. But it was a very interesting decision. What Judge Voorhees eventually ruled on, there were two charges, as you recall, in Gordon's case. One was on the curfew, and one was on failure to report. Well, the judge said, I'm only going to reverse on one of these. I'm going to rule, or he reversed the ruling that actually came down. He denied reversal on the curfew and granted reversal on the refusal to report. So essentially you had it flip-flop, and it really in a way set up the opportunity for us to appeal to the Ninth Circuit, which of course his legal team did. His legal team said, well, you know, we got half of the cake, but we got the wrong half. We need to get both pieces. The government appealed because we won some of it, and they did not want that result. And so the case went up to the Ninth Circuit. The Ninth Circuit heard oral argument and directed for judgment for Gordon on both of the charges. And it's the highest court that has ruled. It is a wonderful opinion if you ever get a chance to read it. And I'm not going to go into it now because we're going to move this panel on.
Thank you, Karen. All right, well, that's it in a nutshell as far as the Coram-Nobis case. But this comes with a challenge to us. And the subject matter overall is the meaning of democracy. So I hope all of you keep in mind a question that I'm going to pose to the panel. And feel free to answer or pass or keep it short or say what you want. But the question is, what light does the Korematsu case in particular, and the Japanese-American story of internment and redress in general, shed on the meaning of democracy in America? So let's start with Bill. Pretty broad question.
So the question really is, can this happen again? Have we learned our lesson? Unfortunately, I think we haven't really learned our lessons. I brought along a book called Wherever There's a Fight. It's the story of the ACLU's involvement in California in cases of segregation, racial discrimination, attack on constitutional civil rights, and it's just constant through our history. The last chapter of the book is about the Japanese internment. And as I read Farewell to Manzanar, I began thinking of situations I was familiar with that seemed to me to be very much like a Manzanar situation. To start with, we have to realize that the United States has 5% of the world's population. The United States has 25% of the world's prison population. The prison population in California has increased 300% since the mid-1980s. We like to lock up people, especially if they are members of minorities or if they are poor. But as I read Farewell to Manzanar, I kept remembering other things, and I had a hard time remembering the name of the book. I wanted to call it Return